So, good morning, everyone. I hope I'm audible and visible also. And hope that you all are doing well. So, how many people have joined so far? I guess three. Only three? Why? Good morning, Xenia. Good morning. I guess it's not too early and it's already 11 a.m. and half of the day is already gone. So I guess you people are still not in your beds and would be joining the class quickly, right? So Soumya is asserting her presence. Soumya is here. Good morning, Soumya. Okay, so conversion therapy in India. We shall be learning about this Madras High Court judgment, this conversion therapy in India, and holding or using this topic as a crutch, we shall be coming across and learning many important nuggets of knowledge and information regarding the homosexuality, legal status of homosexuality in India, and the recognition of the third gender by the Supreme Court. So let us first find out that what this Madras High Court judgment is all about. So this is about a CT, or this is about a conversion therapy in India. So a thorough analysis of the Madras High Court judgment. Now this is a question which is heatedly debated in the Indian political as well as social discourses, because there are groups, there are people who have a clear stand regarding these kinds of issues, like recognition of the third gender, and the LGBTQ group has become a bone of contention for the heated debates in the Indian social discourse. Okay, there are categories which have been made, which have been constructively made over the years to explain this LGBTQ phenomenon in India. Because for me, for example, everybody has a different perception regarding this. For so far as my personal views are concerned in this regard, I would suggest that for me, like recognition of the third gender, like what the Supreme Court did in the Nalsa judgment, the recognition of the third gender, or the issues related with the transgender people are absolutely different from the rest of the people in the group, like LGB and Q. So LGB and Q are different, and the T stands for transgenders. I'm sorry. Sorry. So the T stands for the transgender people, which I personally think that they are absolutely different. Okay, so this conversion therapy in India, thorough analysis of the Madras High Court judgment. So be it the androgynous Ardhana Rishvara, half man and half woman, and androgynous means hermaphrodite or bisexual, or having both male and female traits. So this is an adjective used for a person who has both male and female traits. So androgynous. Or King Ila spending parts of his life as both man and woman. Indian mythology mentions homosexuality but never has it demanded one to go through conversion therapy or therapy, CT or therapy. Okay, so conversion therapy is like Indian mythology. Like this article begins with endorsing that homosexuality is an ancient phenomenon and this has existed in Indian mythology. So if it has existed in the annals of Indian mythology, then somewhere it seems to be justified, like the author is indirectly or tacitly trying to justify the existence of homosexuality through history. Okay, but never has it demanded one to go through conversion therapy. It's like the Indian mythology has never demanded people to go through the conversion therapy. So had it not been for a lesbian couple from Madurai, trans people of Tamil Nadu would have still been exposed to this stringent process without any legal immunity. So there was a case, like you can deduce from the text of the article, that there was a lesbian couple and from Madurai, and they were forced to go undergo the conversion therapy. So trans people of Tamil Nadu would have still been exposed to this stringent process without any legal immunity. The said couple ran away from their respective homes under the fear of separation, and their parents filed a missing report. Okay, so what happened? There was a lesbian couple from Madurai, and lesbian, I guess, like female to female. So the said couple ran away from their respective homes under the fear of separation, and their parents filed a missing report. The police, on finding the couple, interrogated them as to why they ran away. Annoyed by the interrogation and dominating parents, the couple filed a writ petition at the Madras High Court, whereof the single bench in the matter of S. Sushama and others versus Commissioner of Police banned the conversion therapy in June this year. Okay, so they were so much annoyed and irritated by the interrogation and the dominating parents that the couple had to file a writ petition for recognizing and getting their rights endorsed through the judiciary. And in that writ petition, while disposing of that writ petition, the single judge bench of the Madras High Court in this matter of S. Sushama and others versus Commissioner of Police banned conversion therapy in June this year. So this judgment facilitates the increasing scope of Article 21 of the Constitution of India and starts a debate as to how CTs or conversion therapies are futile in contemporary times. These issues will be analyzed in this blog by the writer. So CT or reparative therapy aims at swapping one's sexual orientation to that of a heterosexual. So what does this conversion therapy or reparative therapy does? It aims at swapping one's sexual orientation, like somebody has to get his or her sexual orientation changed, then he or she will have to undergo a conversion therapy or a reparative therapy. So this will swap one's sexual orientation to that of a heterosexual. If somebody happens to be a homosexual and he is going to be he or she is undergoing reparative therapy, then this reparative therapy is going to swap his or her sexual orientation and change him or her to a heterosexual or a straight person. So it evolved from a set of aversion therapies, an assortment for several different therapies used for conditioning human beings, which were first substantiated in India through the Indian Journal of Psychiatry in 1983. So it has evolved from a set of aversion therapies, an assortment for several different therapies. There was an assortment for several different therapies used for conditioning human beings, like conditioning human beings to make them proper, to make them perfect, to remove their flaws and whatever disorders they might be suffering from. All those disorders and handicaps, they were removed, like mental handicaps, they were removed. And these aversion therapies, they were used to condition human beings to make them perfect in living to make them live in a civilized society. So which were first substantiated in India through the Indian Journal of Psychiatry in 1983. So the Indian Journal of Psychiatry in 1983 came out with a research for undergoing aversion therapies. Okay, so this psychiatry is as a sort of like this situation, this biological tendency is concerned with your mental mind, mental setup. Okay, how do you perceive the things around you? How do you see the opposite gender? How do you see the same gender? So this is like related to your mental perception and the way you have been brought up. So, Indian Journal of Psychiatry in 1983. So, a brief history of the issue in Indian parlance. Over the years, the Indian judiciary has tried to take proactive steps to highlight the importance of transgender rights. So, Indian judiciary has been recognizing the importance of the transgender rights in India, because in India witnessed a wave of exhilaration when the apex court in the case of National Legal Services Authority versus Union of India 2014 recognized the third gender, zeroing on one's own estimation of their gender rather than focusing on the biological attributes of it. Okay. So National Legal Services Authority versus Union of India 2014, a very famous judgment of the Supreme Court, in which the Supreme Court recognized the third gender. I guess and I assume that you must be having prior knowledge of this landmark judgment of the Supreme Court, this Nalsa judgment of the Supreme Court from 2014, that this was a benchmark in the history of Indian judiciary, in which the third gender was first, it was recognized for the very first time. Okay, so after which we started having columns in various government forms under the caption of gender, male, female, and others. Okay, like if you take out the reservation forms, then you must have come across this third column in the gender section, and then they have started getting the jobs. They have started applying for the government jobs. They have started appearing for the competitions in the of the government competitions. So I guess there was one, like the Aam Aadmi Party has also given a ticket to someone in West Bengal. I guess so far as my blur memory goes, I guess there was one case, and also in West Bengal there was one transgender who has either qualified PCS or PCSJ. I don't exactly remember. I'm just having a blur memory, but something has happened of that sort. So recognize the third gender, zeroing on, and this is good. Like we have to recognize their rights, and they have their own lives, and they have full authority and right to live like us. Okay. So zeroing on one's own estimation of their gender rather than focusing on the biological attributes of it, paving their way towards a dignified life elucidated under Article 21 of the Constitution of India. They also come under the shadow of Article 21 of the Constitution of India. They are also the citizens of this country. And first and foremost, they are also human beings like us. We have to understand this, and when dwelling upon these contentions, we have to recognize their rights and agree to this contention that they are also supposed to live a dignified life elucidated under Article 21 of the Constitution of India. Okay, so Utkarsh is telling me PCSJ. Okay, she must have qualified PCSJ then. So, in addition, the judgment also recognized transgender rights under Article 14, right to equality, Article 15 and 16, right against discrimination, Article 19(1)(a), freedom of expression, amongst others. So the judgment, the NALSA judgment, the National Legal Services Authority versus Union of India 2014 judgment, also not only recognized the dignified life for the transgenders under Article 21 of the Constitution, but also their right to equality under Article 14, right against discrimination under Article 15 and 16, right to freedom of expression under Article 19(1)(a), amongst others. So besides, it held that nobody who perceives themselves as a third gender will be subjected to any sort of medical examination. This is one of the most underlining statement of the whole judgment, that anybody who perceives themselves as the third gender will be subjected to nobody who perceives themselves as the third gender will be subjected to any sort of medical examination. Like, this is a sort of giving the discretion and the prerogative to the person himself or the herself, that anybody whosoever wants to find himself it has been completely left to the person to ascribe himself or to herself any identity that he or she is comfortable with. There is no need of undergoing any medical examination for finding out or diagnosing the gender or the sex a person has been ascribed with at birth. So the Supreme Court is saying that simply this is the liberty of every person to ascribe himself or herself any gender he or she is comfortable with. For availing the rights of the third gender, it is not necessary that a person has to undergo a medical examination and take the certificate from the medical authorities that he or she belongs to the third gender, and only that certificate shall certify his gender identity. It's not necessary. This is an underlining statement of the whole judgment. Please understand that the Supreme Court has given this right completely to the person himself or herself to ascribe any gender. Like we have been we discussed the difference between gender and sex last evening, right? Like any gender he or she is comfortable with, and there is no need for anyone to undergo any medical examination and take the certificate from the medical authorities to certify his or her gender. That is simple, a straight jacketed formula that anyone who finds himself comfortable with any gender may ascribe himself any gender that he is comfortable with, and it is completely going to be his own discretion and prerogative to take the third column if he or she wants to. So on similar grounds, the case of Common Cause versus Union of India 2018, do you remember this case of Common Cause versus Union of India? What happened in Common Cause versus Union of India? Anyone? How many of you, at least please reply so that I may know how many of you are attending the class or have joined so far. Tarun Kapoor is saying yes, euthanasia, very good. Who is this? Vision, euthanasia. So Common Cause versus Union of India case 2018 was also recognized on the similar grounds. But we are not going to discuss this case. We are going to discuss this case in the judgment summary week. One day will be given to Common Cause versus Union of India. One lecture will be given to Common Cause versus Union of India. Okay, yes, Soumya, very good. Passive euthanasia. Yes, Mohammed Riaz, passive euthanasia. So on similar grounds, the case of Common Cause versus Union of India 2018 was interpreted. Now don't ask me what happened in Common Cause versus Union of India and what is the resemblance between these two cases. We are going to discuss this case in the upcoming week, which will be devoted to the judgment summary week, which is going to be the judgment summary week, and we shall be discussing this case in that week, okay, in the next week, was interpreted. So it is stated that the right to exercise self-determination includes the right to choose, and someone with a competent mental faculty can efficiently choose between different medical treatments. Like since passive euthanasia was recognized in Common Cause case, so this prerogative, this discretion was also given to the person by the Supreme Court, that anybody can have a choice in determining that what medical treatments he or she wants to undergo. Okay, like if a person has a competent mental faculty and he has the discretion or the liberty to efficiently choose between different medical treatments. So anybody who has a competent mental faculty, if he has the liberty and the discretion to efficiently choose between different medical treatments for passive euthanasia or for anything else, then he or she may also have, should also have rather, the discretion and the liberty to undergo any sort of conversion therapy also. If someone wants to swap one's sexual orientation, then he or she must have that liberty and discretion to undergo that conversion therapy. But in this case, the Madras High Court has banned the CT, has banned conversion therapy. So this is what the author is trying to deduce from from the analysis of different case laws, that since these discretions and liberties have been given by the Supreme Court time and again to ascribe any gender to oneself, or to efficiently choose between different medical treatments, then he or she must also have this liberty to undergo any conversion therapy if one wants to undertake or undergo that kind of therapy. Okay. So moreover, in the case of Samira Kohli versus Dr. Prabha Manchanda and another, a basic outline for the procurement of legitimate consent was drawn out. This was followed by the landmark judgment of Navtej Singh Johar versus Union of India, Ministry of Law and Justice. How many of you are aware of this judgment of Navtej Singh Johar versus Union of India? Yes, Tarun Kapoor, very right. Decriminalized homosexuality, right? 377 was made unconstitutional. Baat just badadum. Saksham Sharma has no idea. See, in Navtej Singh Johar, for the people who do not have an idea, I should emphasize on the crux of the judgment. Navtej Singh Johar versus Union of India, Section 377 of the IPC, which criminalized unnatural acts or unnatural sex, was held to be unconstitutional or violative of Article 14, 19 and 21 of the Constitution of India, because everybody was given this right to have his or her own sexual orientation as per his or her own choice, and ascribe himself or herself any identity or any gender identity. This was already held in the Nalsa judgment. So in furtherance of the Nalsa judgment, this was also held that Section 377, which criminalizes homosexuality or acts of homosexuality, has to be held unconstitutional in the light of the Nalsa judgment, and also in the light of proper interpretation of Article 14, 19 and 21 of the Constitution of India. Because whenever we talk about liberty, so every single person in this country at least has the liberty to ascribe himself or oneself any gender identity, and since any gender identity can be ascribed to oneself, then any sexual orientation can also be ascribed to oneself. So yes, Soma Sundaram, it is struck down Section 377. So Navtej Singh Johar versus Union of India 2018 was a landmark judgment, okay, on 6th September 2018. So this was also we are coming across various important cases, but do you know that in what happened in Suresh Kumar Kaushal versus Nas Foundation and others? Do you have any idea about that case? Or do you have any idea about Nas Foundation versus Union of India, the Delhi High Court judgment? Any idea about what happened in that case? See, earlier, the NAS Foundation, one of the NGOs, Delhi-based NGOs, filed a writ petition before the Delhi High Court for holding and finding Section 377 as unconstitutional, and which the Delhi High Court already came out with. Like, the Delhi High Court struck down Section 377 in its earlier judgment of NAS Foundation versus Union of India. Then what happened? Suresh Kumar Kaushal filed an appeal against the Delhi High Court judgment before the Supreme Court, against the NAS Foundation and also against the Union of India. And what did the Supreme Court find out in the 2014 judgment of Suresh Kumar Kaushal versus NAS Foundation? That this LGBTQ is a different classification or a reasonable classification based on intelligible differentia, and so their different treatment in the society does not amount to a violation of right to equality under Article 14 of the Constitution of India. Like, equals are to be treated equally and unequals are to be treated unequally. That was the rule which was applied in the case of Suresh Kumar Kaushal versus NAS Foundation and others. And so the Supreme Court said that Section 377 cannot held to be unconstitutional, and homosexuality in India shall continue to be an offense. This was held by the Supreme Court in 2014. But right after 4 years, in 2018, in Navteej Singh Johar versus Union of India, the Supreme Court struck down Section 377 of the IPC as unconstitutional, and is exactly found the opposite of what it had in 2014. Okay. So yes, baat jazbaat tum. Yes, Soma Sundaram. This was exactly what was said by the Supreme Court. So there were various reasons for reversing for the Supreme Court for reversing its judgment. First of all, there was a privacy case judgment, privacy issue judgment of KS Puttaswamy versus Union of India. So this privacy facilitated, this right to privacy facilitated the recognition of the right to have one's own sexual orientation to be recognized by the Supreme Court in Navteej Singh Johar versus Union of India, and also the Nalsa judgment of the Supreme Court. Excuse me, sorry. So in Navteej Singh Johar versus Union of India came in furtherance of the Nalsa judgment, in furtherance of the privacy judgment, and so the Supreme Court had to struck down Section 377. And it had to find out, it had to come out with a reasoning that whosoever does any act within the four walls of his bedroom is completely a private act, and nobody, not even the state, has the right to tell them that what they are doing is an offense. So this was the simple reasoning which was applied by the Supreme Court in Navteej Singh Johar case, and so this was recognized. And also, since in the Nalsa judgment, the Supreme Court already had said or observed that whatever gender identity one wants to ascribe to himself or herself shall be his liberty or discretion, and no further medical certificate is required to assert or recognize it. Okay, so in furtherance of the Nalsa judgment, in furtherance of the privacy judgment, in furtherance of the reasonings of equality, this Section 377 was held to be unconstitutional in this case of Navteej Singh Johar versus Union of India. So it acts as the yardstick to decide constitutionality of Section 377 and how the demarcation of intercourse between individuals as natural or unnatural is not lawfully sound. With CT getting outlawed in Sushama case, another box for transforming Indian society into a comprehensive one has been ticked, and courts have established their intent to move towards a progressive society. Because when the lawyer was filing this writ petition to hold Section 377 as unconstitutional, then the Chief Justice of India, I told you in one of my lectures, that the Chief Justice of India asked the lawyer that this is unnatural. So the lawyer, to which the lawyer replied that you and me are nobody to decide what is natural or unnatural. If someone is born with that kind of sexual orientation, then that sexual orientation is natural for him. Okay, and we are not the apostles of God on this earth to decide the parameters of natural and unnatural. So this was the reasoning which was applied in this case. So with conversion therapy getting outlawed in Sushama case, another box for transforming Indian society into a comprehensive one has been ticked, and courts have established their intent to move towards a progressive society. Like the Madras High Court in this case seems to go ahead with the progressive outlook that one does not need to undergo a conversion therapy. Only he or she should be comfortable with the sexual orientation he or she naturally possesses. So there is no need to undergo conversion therapy. If, like the Madras High Court, it seems that the Madras High Court would have thought that if we are going to recognize the conversion therapy by law, then the dominating parents or the dominating society would compel lesbian couples or the gay couples to undergo these kinds of conversion therapy again and again. So it is better to outlaw this conversion therapy. So this is what the author is trying to deduce out of the text of the judgment of the Madras High Court. Are you getting my point? If you have any doubt or question, please ask me right away before moving ahead. Please, I'm giving you 30 seconds, please ask me. No questions, I guess. Okay, Riaz. So the aforementioned cases are of huge significance for the transgender community of India, for they not only legally recognize the rights of the community but also paved the way for them to live with honor and respect. So while deciding Sushama case, Justice N. Anand Venkatesh said he was not woke enough and hence took sessions with a psychologist to understand the matter at hand in a better way. So before delivering the judgment, Justice N. Anand Venkatesh was not, was not woke enough, was not having good idea about this issue. So he himself took sessions with a psychologist to understand the matter at hand in a better way. And then based on his sessions and what he understood with the psychologist, he came out with this judgment. So this gesture by a senior member of the Indian judiciary indicates how one can disrupt the party press, and as and when promoted, it will be much easier to guarantee social requisites to the community. Such precedents will also facilitate the advancement in thinking patterns of the members of the society. Okay. Now, psychological analysis vis-a-vis penal provisions. Even if the judiciary walks an extra mile with the pre-existing approaches still in practice, India will only constitute a decremental society. So the writer is trying to say that if the judiciary walks an extra mile with the pre-existing approaches, like without discarding and dumping all those antediluvian thoughts and ideologies of yore, then it is surely going to constitute India, it's surely going to constitute a decremental society. An institution like judiciary, on the shoulders of which completely dwells the interpretation of the constitution and the law, has to have the most progressive outlook and approaches towards making up a society which dumps and discards all the antediluvian thoughts and ideologies or pre-existing approaches which are still in practice in various pockets of India. Okay, so only the judiciary can do that. So the rationale behind promotion of conversion therapy was based on the idea of homosexuality being a mental disorder. Why this idea of why this idea of having a conversion therapy for the homosexuals was promoted? Because this was based on this idea that homosexuality was a mental disorder, right? So the conversion therapies were promoted, and right in the beginning of the article, the author has already said that Indian mythology endorses the existence of homosexuality, but it does not endorses the existence of any sort of conversion therapy or any medical treatment of that time which would cure homosexuality. The society used to live with these kinds of sexual orientation, and it was normal in Indian mythology. So the rationale behind promotion of conversion therapy was based on the idea of I'm sorry, there was a disturbance. So was based on the idea of homosexuality being a mental disorder. However, Psychological Diagnostic Manuals 2013, this is a manual, Psychological Diagnostic Manuals 2013, no longer considers it to be one. Like psychological diagnostic manuals comes out with different researches. So these manuals of 2013 have said that this is no more a mental disorder. Okay. Marriage in Indian society is perceived as a sacrosanct institution for the prolongation of the human race. And it is believed that homosexuality becomes a hindrance to this institution. So marriage in Indian society is perceived as a sacrosanct institution, right? As a sacrosanct institution for the prolongation of the human race. And it is believed that homosexuality becomes a hindrance to this institution. The said therapy is used to eradicate such homosexual or gender identity disorders. Queer and trans youth are often pressurized by their own families to undergo conversion therapy and other procedures which are not performed only by medical practitioners but by shamans, ojas, etc. as exorcism, and are beguiled into believing that their innate perception of gender is flawed. So what usually happens? That queer and trans youth are usually believed to have are usually believed that their innate perception or their own perception of gender is flawed. What they are perceiving of themselves is absolutely flawed and suffers from a mental disorder. Perhaps this has not reached a general acceptance in the Indian society, because a perception of marriage is we perceive marriage as a sacrosanct institution which is for the prolongation and furtherance of human race, right? Human generation. And we have to discard this approach. Only then we can believe in the reasonability of the homosexuality. Marriage is a sacrosanct institution. There is no doubt about it. There is no doubt about it. And it's really different, and it's very difficult and rather impossible for most of the people in the Indian society to not believe marriage as a sacrosanct institution which is primarily made by God for the prolongation of the human race. And the general acceptance of homosexuality in Indian society, it's not easy. People are not going to believe it, or people are not going to live with it for so long. And so there were conversion therapies earlier, and which the parents and the society used to pressurize the trans and queer youth with. So the therapy uses problematic measures, often resorting to extreme sexual violence in the name of corrective rape, which is punishable under the Transgender Persons Protection of Rights Act 2019. So this act has come out with the Transgender Persons Protection of Rights Act 2019. Okay. So the therapy uses problematic measures, often resorting to extreme sexual violence in the name of corrective rape, which is punishable under the Transgender Persons Protection of Rights Act 2019. However, this Act of 2019 only punishes the offender for up to 2 years, whereas rape of cisgender women is punishable with rigorous imprisonment for not less than 10 years under section 376 of the IPC. So the rape of a transgender is punishable with 2 years of imprisonment, while rape of a cisgender woman, rape of cisgender women means who is a cisgender woman? Proper girl, full-fledgedly a girl. Cisgender men, cisgender women. Okay, rape of cisgender women is punishable with rigorous imprisonment for not less than 10 years under section 376 of the IPC. So carrying out such practices without having any scientific backing creates serious complications like gender dysphoria arising out of gender incongruence. Okay, so there is a gender dysphoria, and this arises out of gender incongruence, like gender dysphoria means we do not have proper prisms to look through at different genders. So in conversion therapy, this incongruence is created artificially, which can even lead to death. This also causes mental unrest, hence should be covered under the purview of hurt infirmity under section 319 of IPC. As laid out in Sushant Chandana versus a state and another. Similar principles are also outlined under section 44 of the IPC. Okay. So further, medical practitioners can also attract criminal liability for performing such therapies which constitute medical negligence under section 304A of IPC. So what is there under section 304A IPC? It's negligence. Okay, death by negligence. So usually the cases of medical negligence, they are punishable and covered under section 304A of the IPC. So while conducting any conversion therapy, if there is any medical negligence or the patient dies, because it's very dangerous and prone to death, so any medical practitioner who is conducting a conversion therapy on any patient, and if the patient unfortunately happens to die, then medical practitioners will have to face criminal liability for performing such therapies which constitute medical negligence. So the Madras High Court has, since the Madras High Court has banned and outlawed these conversion therapies for swapping one's sexual orientation, this amounts to medical negligence under section 304A of the IPC, because they are already outlawed, and if the patient unfortunately happens to die, this is going to be punishable under section 304A of the IPC, because the whole conduct of the conversion therapy would amount to medical negligence, and performing such procedures is also a serious violation of ethics, professional ethics. Okay, so have you understood up till here? Have you understood up till here? So often CTs take place in an unauthorized manner in the name of gender affirmation surgeries. Usually conversion therapies are conducted in unauthorized manner in the name of gender affirmation surgeries. Gender affirmation surgeries, like we have to affirm with one of the gender, that are regulated and certain prerequisites are needed to carry out the same. Medical practitioners may attract civil liability in situations of unauthorized surgeries. All of these procedures strike out the principle of free consent featured under section 90 of IPC. Like section 90 in detail enumerates the principles of consent, and so all these procedures, like holding the medical practitioner liable for medical negligence, or conducting any unauthorized conversion therapy in the name of gender affirmation surgeries or would also attract civil liability. It does not matter. It is immaterial. It is immaterial that whether the principles of consent or the procedures of consent were followed in section 90 or not. Even this is irrespective of whatever was done under section 90. This would simply attract civil liability or would be criminally liable, or the medical practitioner or the doctor conducting such gender affirmation surgery, like conducting conversion therapy in the name of gender affirmation therapy, would also attract section 304A of the IPC. Okay, irrespective or notwithstanding all these procedures mentioned under section 90 of the IPC, all the principles mentioned under section 90 of the IPC. Okay, have you understood? Any problem here? So what is the global perspective? Let us first understand how the world perceives it. This was about India. Now what is the global perspective? The queer and transgender communities have been struggling to find acceptance and respect in the Indian society. They're exposed to continuous public brutality, day-to-day belittling, alienation, and also held in contempt of being different from their cisgender counterparts. Okay, so usually this happens that they are subjected to continuous public brutality, that like they are looked down, they are continuously belittled, they are alienated, and or also held in contempt of being different from their cisgender counterparts. Like they do not have a healthy peer relations in the society. They are looked down upon with disapprobation in the society. So all of it eventuates in abuse, self-destruction, or suicide, as happened in the case of Anjana Harish, who was forced by her parents to undergo conversion therapy after she came out as bisexual. Discriminating against queer people on the ground of gender identity and sexuality while limiting their constitutional rights would steer the way towards a pecking order, and the concept of inclusivity will fade away. Okay, so all of it eventuates in abuse. Like usually this happens that people are looked down upon, these people are looked down upon with disapprobation in the society, and this eventually turns into abuse, self-destruction, or suicide, as happened in the case of Anjana Harish, who was forced by her parents to undergo conversion therapy as she came out to be bisexual. Now, if we want to build an inclusive society, the last line of this paragraph says that if we want to build an inclusive society, a society that accepts all kinds of people, all kinds of gender, recognizes a multilingual, multi-religious, and multi-sexual society, then it is important and pertinent for a society like ours to recognize the constitutional rights of these people also. Okay, these people also. And we cannot discriminate on grounds of gender identity and sexuality. Okay, because doing that would steer the way towards a pecking order, and the concept of inclusivity will fade away. Okay. A global survey by International Lesbian, Gay, Bisexual, Trans and Intersex Association ILGA World underlines 4 nations, namely Brazil, Ecuador, and Malta, having countrywide laws barring the barbarous process of conversion therapy. Okay, so which are the 4 nations? Brazil, Ecuador, Malta, and Germany. So Brazil, Ecuador, and Malta already had outlawed this barbarous process of conversion therapy earlier. And recently, Germany brought in a legislation this year which criminalizes conversion therapy for minors and poses a liability towards people who advertise or offer it, and towards parents for the violation of their guardianship. Okay, so these are the four nations. So ILGA World has come out with a global survey naming four nations: Brazil, Ecuador, Malta, and Germany, which have so far outlawed the conversion therapy for minors, and which have also brought legislation to pose a liability towards people who advertise or offer it, and towards parents for the violation of their guardianship. Like anybody who advertises this conversion therapy, that like if any doctor or any medical practitioner or any clinic or any hospital advertises that conversion therapies are conducted here at our place, then those people or anybody who offers it, or the parents who force their minors to undergo conversion therapy, would have to face liability. So the nationwide ban on conversion therapy in Brazil was challenged in a lawsuit initiated by Christian Rosangela Justino, a psychologist who offered conversion therapy to his clients, leading to suspension of his license in 2016. Judge Waldemar de Carvalho ruled in favor of Justino, overruling the nationwide ban. Okay, so actually there was a psychiatrist in Brazil who conducted various conversion therapies, and he filed a lawsuit. His name was Christian Rosangela Justino. He filed a lawsuit which challenged the ban of conversion therapy in Brazil. And since he was a psychologist, and for offering his conversion therapies, his license was suspended in 2016, but the judge ruled in his favor and overruled the nationwide ban. The Federal Council of Psychology condemned this and raised their concerns about how this decision could usher the alarming possibility of the use of conversion therapy. So the Federal Council of Psychology said that we condemn whatever was ruled by the court, and we are concerned about this decision because this would usher us in an alarming situation of wherein the conversion therapies would then be possibly used indiscriminately. Furthermore, it highlights several other countries for having meandering bans under their mental health laws. So there was some mental health laws legislated by various countries, and they had meanderingly banned these conversion therapies. Victor Madrigal Borlaug, an independent expert for United Nations Human Rights Commission, assembled a report on how 98% of those who underwent CT had to put up with physical as well as psychological damage. So they had to, there are any conversion therapy would bring with itself certain physical as well as psychological damage. And that's exactly what Victor Madrigal brought out or found out with. So he was an independent expert for United Nations Human Rights Commission, and he assembled a report and found out that 98% of the people who underwent conversion therapy, they had to suffer some physical and psychological damage. Okay. Moreover, National Center for Lesbian Rights, an American charitable organization, public interest law firm which is dedicated towards elevation of civil and human rights of the LGBTQ plus community, started its Born Perfect, the campaign to end conversion therapy for shielding the LGBTQ community by setting precedents at trial and appellate courts levels across the country. In 2020, more than 300 interfaith religious leaders from across the world came together to sign a declaration that called for a global ban on conversion therapy. This year, Canada's House of Commons, by a vote measure of 263 to 63, approved of the bill C6, now moved to the Senate, that criminalizes CT across the country. Okay, so the conclusion is the way ahead. Like, I don't know. Personally, I don't know whether this conversion therapy is good or bad, or comes with some physical or psychological damage, or it does not. But homosexuality as an act destroys the sanctity of the institution of marriage. And that is an irrebuttable contention. That is my irrebuttable contention, that it damages the sacrosanct principle of the institution of marriage. Okay, for Indian society. Okay, So the conclusion, the way ahead. The Madras High Court judgment includes certain directions for the government for carrying out sensitization programs and Ministry of Social Justice and Empowerment to compile a list of non-governmental organizations or NGOs which will deal with the problems of the LGBTQ plus community and maintain confidentiality of who has approached them. Banishment of CT in Tamil Nadu is that extra mile that India required, but there is a long way to go. Censored by major medical organizations, this heinous procedure is still executed and across the country. The transgender community has been wrestling for their rights and safeguards, and the gradual introduction of regulations for their advancement and preservation is a pressing priority. It is pivotal to develop emotional intelligence amongst members of the society as it signifies farsightedness that is much needed to comprehend the circumstances. Inculcation of fundamentals of homosexuality and trans behavior at a higher secondary level in school, consciousness programs, blanket campaigns inclusive of all genders can be organized by the concerned state authorities for better cognitive recognition. Administering these steps will allow people to become familiar with how to make the non-cisgender community comfortable in their surroundings without feeling estranged. Lastly, it will annihilate the preconceived notion of homosexuality as a disease in a uniform and a structural manner. So I hope you have understood and I have read this conclusion part very quickly. So if you are encountering any doubt or problem, please ask me. I know many of you must be in favor of homosexuality, and many of you might be against it. So there are no doubts and no questions, uh, right? Mohammed Riaz is commenting that it is not a disorder. It is a repercussion of Western culture, and we should find a way out of this. I consider this to be unnatural. Many of us, perhaps majority of us, would find it as a disorder or a repercussion of the Western culture, and exactly this, uh, like this argument is generally bought. Mohammed Riaz. Okay, so let us not engage in the personal debates now, and this is the, like, for many of us this is quite unfortunate. The the era that we are ushering in is very unfortunate for most of us, because the thoughts, the ideologies that we are building around us, and the kinds of approaches that we are developing, that we are trying to develop in our next generation, is are somewhat dangerous, I would say. Okay, so let us not go into these debates. This is a law, and as a law students, we have to, face these things. Okay, and read these things. Sometimes wittingly or unwittingly, consciously or unconsciously, wantingly or unwantingly. So let us not go into this. I am then signing off because I am not getting the questions, and I assume that you have understood the topic properly. Okay. Okay, then. Bye bye till then. All the very best. See you tomorrow.